The Law of Property Act 1925, section 53, subsection 1A, states as follows: subject to the provision hereinafter contained with respect to the creation of interests in land by parole, no interest in land can be created or disposed of except by writing signed by the person created or conveying the same. Oh dear, does law have to be so boring? Well, if you've been to a talk by Professor Endicott, the Dean, when he encourages people to apply to read law, he does warn them that law is very, very boring. And I'm afraid those of you who are reading law will find yourselves bored as you have never been bored before. There are areas of the law which will create depths of boredom you did not know could exist. I won't say what areas of the law, you will find those out for yourselves. But what I just wanted to do today is just to point out that actually just sometimes the law can be fun, the law can be amusing. For various reasons. First of all, because the law involves human beings, and often human beings do all sorts of strange and amusing things. One of my favourite cases is a divorce case called Lines and Lines, which involved a wife who, shortly after the marriage, her husband came home and took his shoes off. And he'd never done this before, and this does sometimes happen shortly after marriage. The husband asked his wife to tickle his feet. And on the first day, this wasn't too bad. It only lasted for 5 minutes or so, and he was satisfied. But the next day it was a few minutes more, and the next day a few minutes more, and within a few weeks it was lasting up to an hour. And she found this intolerable. She suggested a separation, which did take place, and he then promised that if she came back to him, never again would he ever ask to have his feet tickled. But as can sometimes happen with these reconciliations, that lasted only a day or two, and soon he was asking again for his feet to be tickled. And the case ended up in the divorce courts. And the judge noted that as Mrs. Lines gave her evidence, her hands uncontrollably shook in a tickling motion, which showed how sadly she'd been affected. Other cases of divorce have involved the sad LeBrock couples, where Mrs. LeBrock was a woman of firm and stern disposition who liked nothing more than a disagreement. And she grew increasingly frustrated at her husband, who would agree to everything she said, do everything as requested. And eventually she sought a divorce on the grounds that her husband simply wasn't argumentative enough, wouldn't stand up for himself, was too willing to give way. And fortunately the judges saw sense and agreed he was being unreasonably submissive. Another reason why the law can be fun, and excusing present company, is the judiciary. And we can get some wonderful sights into judicial attitude sometimes. One of my favourite cases is a case called Collins and Wilcox, which is about the crime of battery. And the court explained that battery, which involves touching people, needn't always be a crime, because everyday touchings, they explained, can be would not be criminal. And they gave examples of when you can expect to be touched. They said, for example, if you go to a party or to a club, you might expect someone to come up to you and give you a cheery handshake or a hearty slap on the back. And I think that gives you a wonderful insight into judicial parties. Of course, there's always dangers in being a member of the judiciary, and you'd never want to be. So easily a judgment that makes sense at the time can seem so outdated, but a few decades later, and even though many people would agree at the time. One case that is a striking example of what now looks very embarrassing involved a lesbian couple, and the question was whether a child could live with the lesbian couple, a boy. And the court at the time said this is not a normal relationship. But nevertheless, they were willing to let the boy stay with the lesbian couple for 3 reasons. First of all, the court said these are not militant lesbians. They don't try and convert people to lesbianism, and so we can be reassured that that's reassuring. Secondly, the lesbian couple had several male friends who came round to visit, and they could provide suitable male role models. And the third, inexplicably, was that the boy was very boyish in appearance, so the court weren't concerned that he would be affected by this unusual upbringing. Lawyers, of course, love words, and that's what lawyers get involved in. And there's a wonderful joke on this, which goes like this, that a researcher was trying to find out the answer to what is 2 plus 2. And they first of all asked a school child, and the child said, well, 2 plus 2 is 4. So then the researchers went to an accountant and said, well, what's 2 plus 2? And they said, well, we'll have to run that through our computer program several times, and we'll give you the answer next month. And then they went to a lawyer and said, what's 2 plus 2? And the lawyer said, what would you like it to be? And one of the great things about law is you end up with some very, very strange questions. One of the most significant decisions in family law in recent years, Riem, went to the House of Lords essentially on the meaning of the word is. What does the word is mean in the phrase, the child is suffering significant harm? And the House of Lords, in a widely celebrated decision, concluded that the word is means was. And the child was suffering significant harm, then it is, and that was fine. Another infamous case turned on the meaning of the word the meaning of the word unreasonable in a particular statute. Millions of pounds the case cost, with a great array of QCs and the finest legal brains seeking to come up with the definition of the word unreasonable. And the definition provided by the greatest lawyers in the land was that unreasonable means not reasonable. Again, a decision widely celebrated as providing great clarification in that difficult concept. One of the great fun things, of course, about being a lawyer too is when it finally, a case finally comes to court, when all sorts of exciting things can happen. I remember when I did my articles with a very well-known and prominent lawyer, and when I met him, he seemed a rather quiet, rather unassuming figure, and I wasn't sure why he was so widely regarded. But within a week, I went on a case with him, where he was representing a very successful businessman who had been charged with causing harassment, alarm or distress to a police officer. The police officer put a parking ticket on the car, and the businessman had told him to F off. And the police officer arrested him for causing harassment, alarm or distress. The cross-examination went like this. Police officer, when you were told to F off, were you caused harassment? And the police officer said, no. So maybe you were alarmed? And the police officer said, no, I wasn't alarmed. Well, were you distressed? And the police officer said, yes, I was distressed. Were you very distressed? Yes, very distressed. Did you cry? And it was a wonderful question because it showed the absurdity of the argument that the police officer was trying to make. Another wonderful piece of cross-examination went like this: a barrister trying to reassure and calm a young lad, and he said, "Now, Gary," he said, "you must remember that all your responses in court must be oral. Okay, so let's start. Where do you go to school? Oral. How old are you? Oral." You can see where it goes on. Another difficult piece of cross-examination was the lawyer saying to the witness, "So what is your IQ?" To which they replied, "I can see pretty well, thank you." An ominous sign. One of one of my favourite cases is a case called Sutton and Mishcon de Reya. Mishcon de Reya are one of the great city firms used to advising large, prominent corporations on difficult matters of business. This particular case involved two men who wanted to sign a cohabitation contract that would govern their lives living together. And they were living in what they described as a master-servant relationship. And they wanted a contract that would set out their defined roles. So one promised to obey the other in all matters and to receive due punishment in all matters. I think you can only just imagine how the lawyers of Mishcon de Reya would go about constructing such a contract. But there's a wonderful turn of judicial phrase when it came to court, because the enforcement of the contract all turned on whether or not it was a cohabitation contract, a contract to live together, or a contract for sexual services. And the phrase that turned up was that even a moron in a hurry could see that this was a contract with concerning overtones. I love that phrase, a moron in a hurry. And I think that captures very nicely captures very well that phrase. Lawyers, of course, at the end of the day, are primarily concerned about making money. And there's a story about this, and I'm not sure whether it's ever true, if it's actually a true story, but the story goes like this, that somebody phoned up a lawyer and said, excuse me, could you tell me how much you charge? And the lawyer said, yes, certainly, it's £1,000 a question. To which the person said, well, that's very expensive, isn't it? And the lawyer said, yes, it is. And do you have a third question? So as you can see, I think there is a concern there that sometimes lawyers get concerned about money. But we mustn't forget that lawyers also achieve a great deal of justice. There was a heartwarming case in the Derby County Court recently. A woman phoned up a radio station which was offering her a prize if she answered the question correctly. And she was going to get a Renault Clio, which is a car. And she correctly answered the question. She turned up at the radio station to collect her prize, and they gave her a little car that size in a Renault Clio. I'm pleased to report that the Derby County Court awarded her £8,000 damages so she could buy a proper sized Renault Clio. She did much better than someone called Kathy McGowan, who had committed an armed robbery on a shop. And the next day saw a picture of herself with lottery winner underneath. It was a grainy photograph, and it said, please go to your local police station if you're in this photograph to claim your reward. So she rushed off and of course was immediately arrested because it was a photograph from the CCTV. So I hope in your law studies, although there will be times when you face cases which are hard to understand or perhaps a bit hard going, you also look out for cases which are more fun, and I'm sure you'll find amongst some of the tedious details some also fascinating insights into human nature and to how people are. Thank you very much. Yeah, and there's no doubt the fear of litigation, I think, means people will go to inordinate lengths to make sure that they are protected. And you get the concern, for example, in the medical arena of defensive medicine, where doctors are doing procedures or recommending courses of action simply to avoid liability, and they're not actually benefiting the patient or not. And so you're right. There is, I think, sometimes can be a dark side to some of the more absurd claims that are publicised.